Greetings! Welcome back to episode 6 of the Courts and Trials process. Today we are going to look at the first of 3 stages of our trial process. And this will be the pre-trial stage. Episode 7 will look at the trial stage, and then episode 8 will deal with the jury. When we talk about the pre-trial process, we have to understand that, again, just about every criminal case will not advance beyond this step in the process. 90% of the criminal cases are going to end up with a guilty plea. But that is not the only way that the pre-trial stages divert cases from the typical process. One way that we can divert cases out of the court process is through specialized courts. And this ties in with a desire to provide treatment for offenders, to rehabilitate offenders. We're going to look for the underlying causes that are leading to the criminal activity, and we're going to create specialized courts to deal with those particular problems. This began in the early 1990s with the drug courts. People began realizing that the same people were going through the court process over and over again, and so rather than simply just process them through the court system, we needed to try to address the underlying causes of their drug activity. And so they created drug courts. The idea behind the practice of drug courts was that the defendant would be charged with the crime, but then they'd have their case pulled out or diverted from the regular process, and they would undergo special treatment overseen by the judge, overseen by addiction professionals, overseen by the prosecutor, overseen by a public defender. They would all work together to help people through this process. One particular system involved generally an 18-month to a 2-year process that worked in 3 stages. There was an intensive treatment stage where they would try and get the person clean. Then there would be a transition stage where they would provide educational opportunities, job opportunities. They would begin doing counseling in terms of how to manage the addiction. And then finally there was a 3rd stage where they would be working out in the community. They would be endeavoring to stay sober or stay clean, and they would be monitored through this last process. And if they successfully completed that, they would actually have their case dismissed. And so there was never a record of it in terms of public files. Other jurisdictions copied this. Some did it after a guilty plea, some would do it before, some would have different stages in the process. They would have rewards, they would have punishments if they didn't perform appropriately. And they ultimately found that these programs had a pretty good success rate. There is certainly some mixed evidence about it, but for the most part they were beneficial. As a result, people began thinking they could apply this to other types of offenses as well. Domestic violence courts soon followed, where they began taking offenders and making them take anger management classes by finding ways to redirect some of their frustration or their anger rather than taking it out on another person. They also created mental health courts where they looked at the relationship between mental illness and criminal activity and sought to reduce that by getting people the mental health treatment that they needed. All of these cases, if they complete this process successfully, they are set free from the criminal process. And these are cases that are diverted out of the system. There's other ways, however, by working within the process to divert cases out or to eliminate cases from a particular judge's docket. The most common method is what we call a motion to suppress. And there's 3 different motions to suppress that are in existence. You can move to suppress evidence, you can move to suppress statements, you can move to suppress identification. The first motion to suppress evidence basically comes into play whenever there's a question about whether the investigators seized evidence in a constitutional fashion or not. This is a really long and complicated set of issues that arise. There's lots of different fact situations that show up, and there's lots of ambiguity, especially as we move into more computerized evidence and more of an information age. There's a question about whether and when law enforcement can get access to some of that information. Next is a motion to suppress identification. This arises when the law enforcement investigating the case attempt to have one or more victim or witness identify their potential suspect. This can occur in several different ways. It can be through showing photographs. It can be through a physical lineup. It can be simply showing the person arrested at the scene, is this the person who assaulted you or robbed you or stole from you or whatever. Basically, the U.S. Constitution says that these lineups cannot be unduly suggestive. So in other words, you can't have the defendant in an orange jumpsuit and then have 4 other police officers in a physical lineup. The witness who is making the identification is clearly going to pick out the person in the orange jumpsuit. So if that occurs, then that identification would need to be suppressed. It could not be used in court. The final aspect is our motion to suppress statements. And I want to spend a little bit more time on this to give you an idea of how this process plays out. As you may be aware, there was a decision called Miranda versus Arizona. It was actually one of 5 different cases the Supreme Court considered at once, looking at the question of coerced confessions. From that case, the court decided on the Miranda warnings. You have the right to remain silent. Anything you say or do can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be supplied for you. These basic rights have to be given to any defendant prior to the beginning of what's called custodial interrogation. And that has 2 different pieces to it. What is custody? What is interrogation? What is custody is a very ambiguous notion. It has something to do with whether the person feels free to leave or is actually free to leave. It has to do with where the questioning is taking place. Basically, you're looking at the totality of the circumstances to determine if this person was in fact in custody or not. Then what goes along with that is the question of interrogation. Interrogation implies at least asking questions of the suspect, but it can also mean saying anything in which the person may feel the need to respond. And so if you have custodial interrogation and you do not inform the person of their rights, those statements can be suppressed. And that's going to go through a particular court process. It's going to begin when the defense files a motion to suppress statements. And in that motion, they have to say their client was subject to custodial interrogation and they were not properly given their warnings. The prosecutor is then going to have to respond by saying, no, they did get their warnings. This is going to lead to a hearing in court where the prosecutor is going to present the investigators to explain how they obtained the statements from the defendant. The defense is then going to have the opportunity to question the witnesses, and the judge is going to make a ruling. If the judge rules that the statements were obtained in violation of Miranda, then those statements cannot be used in court. And it could be a case where that confession is what connects the defendant to the crime. So let's say you have a murder. The only evidence that the defendant actually is the one who committed that murder is the confession. If that confession gets thrown out, you may not have a case against that defendant anymore, and as a result, the case may have to be dismissed. This is going to happen most frequently in motions to suppress evidence because they usually occur in drug cases, and if you suppress the drugs, then you don't have a case, and the case has to be dismissed. But it can also occur in identification and statement suppression cases. Now, in addition to these motions to suppress, we may also have other pretrial motions that arise prior to trial. These are going to not necessarily dispose of the case, but they can certainly make the case better or worse from both the prosecutor's and the defense standpoint. The first motion that we can consider is a motion for change of judge. This is going to occur whether we have an individualized docketing system or a centralized docketing system. It's going to happen more frequently in an individualized docketing system because that's the only way you're going to get the judge changed. Sometimes a particular defense attorney may not get along with the judge, or they may not like how the judge sentences particular types of cases. So the defense attorney is going to file a motion to change the judge. Usually most jurisdictions allow one change of judge per case unless the judge who's hearing the case for some cause cannot hear the case. Then we will also allow change of judges for that. Prosecutors also have the opportunity to change a judge, but because they're constantly working with the different judges in the courthouse, very rarely will judges or prosecutors actually seek a change of judge. The second motion that can be filed is a motion to change venue. Defendants have the right to be tried in the location where the offense occurred. This allows the jury to decide on the legitimacy of the charge, whether they believe this conduct is criminal or not. Different places have different views about what should and should not be criminal. But sometimes a case receives so much attention that many people have already heard about it and many people have already made their decision. If we go back to the Stephen Avery case, for instance, that case was very highly publicized when it occurred in Wisconsin. As a result, the defense asked the judge to move the case to a different jurisdiction so that they could get a jury that didn't know as much about the case and might be a little less biased. In that particular case, the judge denied the change of venue, but at least allowed the case to be tried in a different jurisdiction using jurors from the county where the crime occurred. Generally, the defense would have to show that there is a very high percentage of jurors, potential jurors in that jurisdiction who have formed an opinion and will not be able to set that opinion aside in order to decide the case. A third set of motions is motion of severance and joinder. Prosecutors, when they file cases, judges, when they hear cases, want to have as much put together in one case as possible. It promotes judicial efficiency. If we have 5 different defendants on a criminal case, we don't want to do the same trial over and over and over again 5 different times. Instead, let's put them all together in a single case and we can resolve the case all at once. However, there may be instances where defendants want to have the cases separate. Of those 5 defendants, the evidence may not be very strong against one of them. And so that one person may say, look, I don't want to be lumped in with all of these other defendants. I want my case to be tried separately. The judge is going to look at that and then make a decision. You can also do that with counts. You may have one person charged with 5 different murders, and the evidence implicating the defendant may be very strong on 3 of those 5 murders. And the defendant may say, I want to have these other 2 murders tried separately from these first 3 because I don't want the jury to assume I'm guilty of these other 2, even though they may find me guilty of the first 3. Ultimately, it's the judge's discretion about whether or not to sever charges or counts. There's one requirement, though, when it comes to severing defendants in a case. If there are co-defendants and one has given a statement implicating the other, those cases must be tried separately. Otherwise, you're going to run into cross-examination, right to confront witness problems, and we're going to have to choose between right to remain silent and right to confront witnesses. By severing the trials, we're able to avoid that particular problem. The final motion that we have is a motion for discovery. As we talked about in the pretrial as we talked about in the second episode, looking at the court process, discovery involves the disclosure of information from the defense to the prosecutor, from the prosecutor to the defense. So as the defense continues to investigate and think about their case, oftentimes they're going to want particular information, or they may ask if certain information is available or exists. They may ask for a lab report, or they may ask for a fingerprint comparison. As they do this, they're going to make a motion for discovery, basically asking the prosecutor to disclose that information to the defense. And if the prosecutor says no, then the defense is forced to go in the court to compel the prosecutor to give that information. And of course, this works the other way as well. The defense may rely on an insanity defense and have all of these expert witnesses lined up and then not disclose the reports. The prosecutor will ask, the defense will say no, and then we go to court to try and resolve that. Ultimately, as these pretrial matters are addressed and resolved, they're all done so with the aim to the next step in the process. And that's what we will cover in episode 7, the trial.